Your Lordship. Lordship, I beg to mention a writ petition, Your Lordship, along with an IA. Petitioner is in detention camp, Your Lordship. For listing for tomorrow, Your Lordship.
Okay.
May I please, Your Lordship, my lord, I am writer number 10, my lord. This matter may be adjourned for the day.
Okay. But it goes for 2 weeks. Okay. Item 10 is after 2 weeks as paid for by and counsel with the petitioner. You just said both sides are represented.
Item 8 also, my lord, or 2 weeks.
Item 8.
8.
Today we are allowing it is as a exception to the rule. But if on Tuesdays and Thursdays you don't give us prior information, we are not adjourning any matters on these days, on Tuesdays and Thursdays.
Sorry.
Today we have some administrative works, therefore we are
After 2 weeks.
item 8.
Yes, sir.
Okay. Item 8, same.
All right, sir.
May I please, the Lord, so I beg to mention one writ petition to come up on Friday, my lord, for admission. My lord, this
Writ
matter,
petition is relating to what matter?
my lord, it is for custodial debt, my lord.
Okay.
Division bench matter on 16 May, it was listed, but matter was left out, my lord, due to the paucity of the time.
Okay.
May I please, your lordship. My lord, item number 4, I am paying for adjournment for 2 weeks, lordship.
Item number 4.
4, lordship.
You want an adjournment?
Lordship, maybe taken after.
Okay. Same order. Item 4.
May
But
I
this is
please
an
have a-
exception today.
Lordship.
Yes.
May I please, Your Lordship, I am praying for listing an IA in connection FT matters. So,
Okay.
for tomorrow, Lordship,
Due to the court master, they'll have to adjust.
medical urgency, so.
May I please, your lordship, Lordship, item number 9, lordship, after 2 weeks, lordship. Item number 9.
9.
Yes.
Okay. Same.
So there is an interim order, lordship, interim order may contain.
We don't give interim orders, limited interim orders. Have you checked the order?
Yes, sir, your lordship, and on last occasion, it was interim order continued, for that I have said,
Okay, just wait for some time. Let us get the file. Item
9.
9. Okay. Yes.
Lordship, item number 15, Lordship, I'm praying for adjournment, Lordship. May be taken after 2 weeks.
15.
Fixed. Lordship, 1-5.
Okay. Same order, 2 months.
1-5, 15. Bless.
Not a beg to mention, the matter may be listing on Friday.
Listing you to the court master.
No, file to be-
Being mentioned. Not required.
Item 1 for hearing.
May please, your lordship. Lordship, for the time being, lordship, my senior lives in other portion.
Okay.
For the time being. Bless.
Item 2.
Lordship. In this case, Lordship, it's a contested case. May it please, your Lordship. This is a contested case, Lordship. The impugned order is at page 38. Annexure 14, page 38. Land document, Lordship, I have not annexed along with this writ petition, but Lordship, it is exhibited, it is in the LCR, Lordship. Land document, Jamabandi, exhibit 10, and gift deed, exhibit 11, Lordship. Kafatul. May I start? Lordship, the impugn. Lordship, the impugn order is at page 38. The OP tried to prove his case by Lordship exhibiting 1966, 1970 voter list. Lordship. Give it, Lordship. Give it, Lordship, in evidence in chief, we have stated and exhibited as exhibit 10 and 11, Lordship. Jamabandi 10 and give it 11. Executed by Father Karim Bok Sheikh in favor of the OP, Lordship. And his sister, along with his sisters. Lordship,
You have checked these documents
LCR, I have not gone through, Lordship.
because this is the only thing we were discussing.
The give it, Lordship.
Mr. Sharma, please
Look.
look into it. You see, in the Jamabandi, first look at the second document, that is the give deed. Muhammad Sukhitan Nessa,
Mother.
Swami Korimbok Sheikh. Now look at the entry number 2 in the Jamabandi. Sukhitan Nessa, Swami.
That is the discrepancy, Lordship. In all the voter lists, somewhere Abdul Karim, somewhere
No,
Karim.
but this is not a voter list. This is your document.
Lordship.
This gift deed is of 1989. It's a post 71 document, but it doesn't connect you to your father.
Lordship, in all the documents, Abdul Karim has been shown as somewhere Karim Baksh Sheikh, somewhere Karim Baksh, and in somewhere Abdul Karim, Lordship. For these already there were 2 orders passed, and accordingly we have filed the entire voter list of earlier years, 1977, 1959, 55, Lordship. Only this is the main discrepancy in regard to the name of the father of the OP, Lordship. They somewhere written as Abdul Karim, but Lordship address remains same, Kalikura Part 2. Since 1966 till they are in Kalikura Part 2, Lordship. And this gift deed shows, Lordship, it was executed by Karim Baksh in favor of Sukhitan Nessa, first of all, Lordship. Then in second place, Abdul Jabbar, that is the OP, Lordship. But in Jamabandi Chokro Bikhoyar 11-10-2017 তারিখৰ নামজাৰি নম্বৰ so-and-so হুকুম মৰ্মে 53 নম্বৰ দাগৰ মাটি.
Because you see the police reference is of 2016.
Yes, Lordship, 2017. That is in by
So
inheritance.
therefore, this is after the reference was registered before the tribunal.
Lordship.
Only after that, this correction of name has taken place.
Lordship, as because after by inheritance, Lordship, that is. Lordship will find here it is written Uttaradhikari Hutre Abdul Karimor Stholot Jobahar Begum Pitri Karim Baksh Sheikh. Once Abdul Karim and again it is written as Karim Baksh Sheikh and Sahera Khatun Pitri Karim Baksh Sheikh, Nurjahan Nessa Pitri Karim Baksh Sheikh and Abdul Jubbar Pitri Karim Baksh Sheikh namot namjari kora hol.
What do you say that is the correct name of your father?
Karim Baksh Sheikh, Lordship. In my read petition, I have stated so, Lordship. There are 2 page 4, Lordship. That the petitioner states that he is the grandson of late Miajan and late Kajoli Bibi, who were the permanent resident of village Kalikura of the then Gwalpara district, now Bongaigaon. The petitioner's grandparents have only one son, namely Karim Baksh Sheikh. That is the father of the petitioner, being permanent resident of village Kalikura Part 2 of erstwhile Gwalpara district. The names of the petitioner's grandparents enrolled in the voter list of 1966 for village Kalikura Part 2. Under 42 Obhayapuri SC LSC. In the said voter list, the name of the petitioner's father was also recorded with his parents at serial number 16. Similarly, in the voter list of 1970 of the aforesaid village, the names of the petitioner's father as well as grandparents appeared. I have enclosed both the sale deeds, Lordship 6670 as annexure 1 and 2. Then I have, Lordship, it is also stated that it may be mentioned here that though the name of the petitioner's grandfather is Miajan, but as he performed Hajj, he was also known as Miajan Haji or Haji Miajan. As such, in the aforesaid voter list, his name was recorded as Miajan Haji. The annexures, Lordship, that is 1960 voter, 66 voter list, page 18, Lordship. These are the discrepancies, Lordship. Sometimes they say, Lordship, it is Miajan Haji. Your lordship will find 1966
But
serial number.
If your father had done Hajj, you would have a passport.
Lordship, 1966 voter list, kindly see serial number 14, house number 6, Miazan Haji, my grandfather. Against his name, Rofu Sheikh, my great grandfather. And then Kajoli Bibi, against her lordship, this Miazan Haji now becomes only Miazan. These are the discrepancies, lordship, while recording the name of the person's lordship were done by the
No, we are not on that.
lordship.
This description of the Miajan Haji and Miajan in the so and so, this is, we are not questioning that for the time being.
So this Karim Baksh Sheikh has become Karim Sheikh in 1985, page 20, lordship. And Abdul Karim in page 21, annexure 4. But against his father's name, always it is written as Haji Miajan or Miajan Sheikh, lordship. Only the discrepancy in the voter list and discrepancy in the age of the electors in the voter list, that was recorded by the tribunal, lordship. And that can be seen from all these annexures that, lordship, there are some slight lordship discrepancy in the names, lordship. Annexure 2, page 19, lordship, kindly see Miajan Haji against his name Rofu Sheikh, then Kajoli Bibi, his wife, against her husband's name Miaja Bibi, lordship. And against Karim Baksh, his father's name written as Miaja Bibi. The same person's name appeared in serial number 14 as Miajan Haji, who became lordship Miaja Bibi subsequently.
Just a moment.
No. Jawahar Begum, এক নম্বরে। কিন্তু সুকিত জওহর, মানে ইয়াত লিখিছে এটা, ইয়াত বহাইছে এটা। তো এইবিলাকতো এনেকে যিহেতু ইয়াতে তোমাৰ উচ্চমতে তুমি তেতিয়া
certificate হয় না? Certificate copy হয় না?
তো তোমাৰ ৰেফাৰেঞ্চ পাইছো আৰু আজকে দেখা হৈ আছে। পঢ়াটা আছে। মানে দেখুন জওহর।
With 6 plus. এখানে জমাবন্দি এখানে নেই। It's 1982. এখানে ওপরে কেতিয়া কৰিলে লেণ্ডটো
সেইটো তাতে লেখা মানে মিছপ্ৰুভ আৰু এই অৰ্ডাৰটো আনিব।
In respect of this annexure 5, do you have a copy of any magisterial order for registration of birth
No, Lordship.
beyond a period of 1 year?
No, Lordship. That was obtained later on, Lordship. It is reflected in the tribunal's order, Lordship. That is to show only that my father died in the year 1993, Lordship. But Lordship, to show leakage, I have already submitted enough documents, Lordship, the voter list, including, Lordship, the land documents. And in WPC 9231, it was already held that, Lordship, that the land documents cannot be discarded only because of this, and the name and age of discrepancy in the voter list cannot be, Lordship, discarded. And that cannot be a ground for declaring a person to be a foreigner, Lordship. I have 2 copies, Lordship. May I submit? Lordship, thus, in a similar facts and circumstances, Lordship, WPC 9231 was remanded back to the learned tribunal to decide afresh, considering the voter list and the order by which the name correction was done by the circle officer, Lordship, comparing all those orders and the voter list. Para 4, Lordship. Para 4, the tribunal in its opinion dated 29/10/2019 rejected the exhibit 11 Jamabandi with an observation that the document is not sufficient to prove that Habib Rahman of exhibit 1 and 2 and Habibur Rahman of exhibit 3, 4, 11 are one and the same person. If the name of Habib Rahman appears in the voter list of 1966 and 71, and that of Habibur Rahman in the later voter list of 1985, and the Jamabandi contains the information that the land which earlier stood in the name of Habibur Rahman has been mutated amongst others in the name of Farhad Ali, the same may prima facie discharge the burden under section 9 of the Foreigners Act 1946 that the petitioner proceeded. Farhad Ali is the son of Habib Rahman or Habibur Rahman of the voter list of village Lotibari Part 3. No material is available on record to show as to why the tribunal was of the view that the documents are not sufficient to prove that Habib Rahman of exhibit 1 and 2 and Habibur Rahman of exhibit 3, 4 and 11 are one and the same person. Once the initial burden had been discharged, it is for the respondents to rebut such evidence, and in the absence of any rebuttal evidence, we see no material as to how the tribunal can arrive at its conclusion that the documents are not sufficient to prove that Habib Rahman and Habibur Rahman are one and same person. No material is also available on record which may show that the names of Habib Rahman and Habibur Rahman appear together in the same document to give an indication that they are different person. In Sirajul Haq versus State of Assam and others, 2019 5 SCC 534, the Supreme Court was of the view that the minor variation in the spellings of the same is not to be made a basis to conclude that the two persons may be different persons. It is also noticed that the tribunal, by taking note of the discrepancy in the age of the person in successive voter list, often rejects the voter list itself to be unreliable by indulging in arithmetic calculation. For example, if a person is shown as 40 years in the voter list of 1966 and in the voter list of the same village he is shown as 55 years, often it is noticed that arithmetic calculation are made that the age ought to have been 51 years and not 55 years. Accordingly, reject both the voter list. Upon a query raised with the Election Commission, the Learned Counsel appearing for the Commission upon instructions candidly admits that the voter lists are not prepared which are immaculate accuracy as regards the age of the person depicted therein, and therefore an arithmetic calculation may not be the appropriate indicator to reject all the voter lists. We also have to add that although minor discrepancy in the age of the persons depicted in the voter list may not be of such relevance, but a substantial variation in the age may also be an indicator that the persons appearing in the voter list with such wide variance in the age may be different persons. Further, Exhibit 11 is noticed to be a Jamabandi, which is referred to be a draft chita on the, in the opinion of the tribunal dated 29/10/2019, but again the said Jamabandi appears to be a certificate generated by using Dharitri, which is designed, developed and maintained by the NIC Assam, and the copy of the Jamabandi produced by the petitioner is available in the records of the tribunal. A perusal of the Exhibit 11 makes it discernible that it is a computer-generated printout, which is a certificate generated by using Dharitri, which again is designed, developed and maintained by NIC Assam, and the document also contains the seal and signature of the circle officer of Srijangam Revenue Circle, including the round seal. The Exhibit 11 being a computer-generated certificate by using Dharitri containing the seal and signature of the circle officer, the evidentiary value of the same would be governed by Section 65B of the Indian Evidence Act. Thereafter, Lordship, relying on these documents, Lordship, it was remanded back. Paragraph 16, Lordship. In view of above, we remand back the matter to the tribunal to examine the complete voter list of the years 1966, 70, 77, 1985 in respect of the village Lotibari Part 3 as well as the information contained in the Exhibit 11 Jamabandi, and pass a reasoned order. The petitioner to produce the complete voter list of the aforesaid years as well as the order of the circle officer dated 18/1/2017 by which the land was mutated in the name of Farhad Ali amongst others in place of Habibur Rahman. If the tribunal desires, the original records of the mutation case number so and so may also be called for to verify under what circumstances the order of mutation was passed and whether it is acceptable in law to establish that Farhad Ali is the son of Habibur Rahman of village Lotibari Part 3.
No.
In this case also, Lordship, the name of the father of the petitioner, Abdul Karim Karimbok Sheikh Karimbok, Lordship. These are the discrepancies, and Lordship, some discrepancies in the age also.
Yes, Mr. Sharma.
May I please, your lordship? Your lordship. My humble submission is that there is no infirmity in the opinion passed by the learned tribunal lordship. And lordship, your lordship, if see the voter list lordship, 1966 and 70 lordship, this is fine lordship.
But there's one force in the submission of on behalf of the petitioner that the village is always the same.
Maybe,
Kalipura Part 2. There's no shifting. So therefore, discrepancy of name may be a factor which can be covered by this judgment of Farhad Ali shown by her.
no, my lord. Not only discrepancy of name only, lordship, there is also lordship discrepancy regarding age, lordship, and after 1966 and 70, these are okay, lordship. After 1970, lordship, there is a long gap between 1970 to 1985, lordship. So there was no continuous stay. And after that, lordship, since 1985, lordship, their ages are gradually decreasing, lordship. Each and every document, lordship. Instead of in 1985 document, lordship, father's is become 1970, whereas his age should be 1970. His age should be 59, lordship, instead of 70, lordship. It is not minor discrepancy, lordship. 11 years discrepancy is not a minor discrepancy, lordship. And
11 years.
instead of
refers to
59,
which?
it becomes 70, lordship, in 1985 voter list. 1966 and 70s.
1966, yes, which?
1966, lordship, at page, lordship,
18,
18.
yes.
Here, lordship, Korimbok's son of Miazan, 40 years, aged about 40 years, and lordship, 1970 is also same lordship, 44. After 1970, lordship, discrepancies arises, lordship. 1985, Korimbok's become 70, and Sukiton Nessa names first time appeared at the age of 70 years, lordship. First time appeared, lordship. And written statement is totally silent about Sukiton Nessa, lordship. Although now he's projecting she is the mother of the proceedee, lordship. And lordship, then 1989 voter list. This is different village, Lordship. Kalikura Part 1.
Those are not very material. Part one, part two.
Yes, Lordship. This is, and
Next
Lordship,
voter list is 1997. It again is
it-
part two.
again is Part 2, but Lordship, in 1989 voter list, Lordship, there's Abdul Karim's names reflected. I think he's the, Abdul Jabbar, Lordship. Abdul Jabbar's name reflected, Lordship. He is a
Petitioner.
present petitioner. And this is Kalikura Part 1. Age is aged about 23 years, son of A. Karim. Petitioner projecting as Abdul Karim, this person. Then Lordship, 1997 voter list, Lordship. Here again, after 1989, Lordship, after a gap of 8 years, Lordship, these persons become Jabbar Ali Sheikh, son of Karim Baksha Sheikh, aged about 26 years. Instead of 31 years, Lordship, he becomes 26 years. And similarly, Lordship, Sukitan
Just a
Nesas,
moment. Just a moment. Yes, 26 years then.
And Lordship, again, Lordship, regarding Sukitan Nesa's age, Lordship, since 1985, Lordship will kindly see, Sukitan Nesa was aged about 70 years. Then in 1981, different village Kalikura Part 1, he becomes 60 years. Again, in 1997, he became 55 years, gradually decreasing, Lordship. So,
Yes.
then Lordship, so these discrepancies are not minor discrepancies, Lordship. And apart from that, Lordship has already pointed out, Lordship, here in the gift deed, Lordship. This Jamabandi, Lordship, it was in her written statement, Lordship, her father when died, Lordship, that was not mentioned, I think, Lordship. And after, although after that, Lordship, he stating that, Lordship, she proceeded stating that his father died something in the year 1993, but there is a death certificate, it was registered in the year of 2017, Lordship. And after collecting this death certificate, this Jamabandi was created, Lordship. And the although there is in serial number 2, Sukitan Nesa's name was there, Lordship, but in order column, Lordship, Montobbo, in Montobbo column, Lordship, there was no Sukitan Nesa's name was appearing, Lordship.
Just a moment. Page number.
It was not annexed, Lordship.
Okay.
Yes.
Please repeat again.
Lordship, here
That is exhibit number.
exhibit number 10, Lordship. Exhibit number 10, Jamabandi copy, Kalikura Part 2. Here, mother of the petitioners, Sukitan Nesa's names appearing at serial number 2. Here, wife of Abdul Karim's, not Karim Boxa Sheikh, Lordship. And in Montabbo Column, Lordship, there was nothing about Sukhitan Nesas, Lordship. How you acquired this land, Lordship. And Lordship, there in exhibit number exhibit number 14, Lordship. Exhibit number 14, Lordship, there this is a recent document, Lordship, next to kin certificate. It was also obtained in the year of 2017. Although person concerned was died in the year of 1993, Lordship. And Lordship, how far my knowledge is concerned, Lordship, I think, Lordship, only on the basis of a self-sworn affidavit, Lordship, this next to kin certificate can be obtained, Lordship. And here also, Lordship, Sukhitan Nesa's name was not mentioned, Lordship. Next to and this was obtained after the 23 years after the death of the person concerned, Lordship, whose name reflected in the 1966 voter list, Lordship. Then, Lordship, on such documents, Lordship, tribunal cannot such documents cannot tribunal cannot accept such document, Lordship, upon such discrepancies, Lordship, if tribunal cannot accept these documents, Lordship. And Lordship, now I am translated copies of voter list, Lordship. All these voter lists are translated copies of voter list, Lordship. And regarding translated copies of voter list, Lordship,
How do you come to a conclusion that this is a translated copy?
because here it was written as Lordship,
Which page?
is Lordship.
Page 24 also. All the in all the voter list, Lordship, it is already
Page
written.
24 on
Only 1970 is written that certified copy of page 19.
Just a
Lordship.
moment. Just a moment, come back to you.
Lordship,
Let Mr. Sharma complete his,
Lordship.
yes, Lordship.
yes, page 24.
Page 24, Lordship. Then, Lordship,
No, where it is written that
just a minute.
translated,
Page 20, Lordship,
page 20.
of the writ petition,
Yes,
translated copies of electoral rolls.
okay.
And Lordship, then 21, then Lordship, 23, 24, except Lordship, page 18 and 19. In all other voter list, it was written as Lordship translated copies of voter list. So regarding that, Lordship, I want to rely on a decision of this court, Lordship. WPC 2460 of 2016.
Just a moment. Yes, which judgment?
WPC 2460 of 2016.
2016.
Yes, Lordship.
Name
2460
of the parties?
ISIRAN, ISIRAN. NESSA, NESA
Hmm.
versus Union of India.
Decided on
Decided on Lordship 10/4/2018.
10?
10/4/2018. 10th of April 2018. Lordship. Lordship, can I read the relevant paragraph, Lordship? Exhibit A and D are translated copies of electoral rolls of 1966 and 1970. Question for consideration is whether a translated copy of electoral roll can be constituted as an admissible piece of evidence. Further question is whether translated copy can be considered as a certified copy and does an admissible piece of evidence. Black's Law Dictionary 6th edition has defined certified copy to mean a copy of a document or record signed and certified as a true copy by the officer to whose custody original is entrusted. Section 61 of the Indian Evidence Act 1872 deals with the proof of contents of documents. Contents of documents may be proved either by primary evidence or by secondary evidence. While primary evidence is explained in section 62, section 63 deals with secondary evidence. As per section 63, secondary evidence means and includes certified copies. Copies made from the original by mechanical process ensuring accuracy of the copy and copies compared with original, copies made from the compared with the original, etc. Section 65 deals with cases in which secondary evidence relating to documents may be given. It says that secondary evidence may be given of the existence, condition, or contents of a document in the cases mentioned therein from clause A to G. As per clause E thereof, secondary evidence may be given when the original is a public document within the meaning of section 74. Section 74 explains as to what are the public documents, and section 76 deals with the certified copies of public documents. As per section 76, every public officer having the custody of a public document which any person has a right to inspect shall give that person on demand a copy of it on payment of legal fees thereof, together with a certificate written at the foot of such copy that it is a true copy of such document or part thereof, and such certificate shall be dated and subscribed by such officer with his name and his official title, and shall be sealed whenever such officer is authorized by law to make use of a seal. Such copies so certified shall be called as certified copies. On careful and conjoint reading of the aforesaid provisions of the Evidence Act, together with the definition of certified copy, we are of the unhesitant view that translated copy of such as Exhibit A and D cannot be constituted as certified copies and therefore cannot be treated as secondary evidence. This position is further strengthened if we look at Lordship. I think this is not necessary. So Lordship, if required, I have only one copy, Lordship. Lordship can. ইয়াত এটা flag দি দিব হা। Then Lordship, If we accept this voter list lordship as a valid piece of evidence lordship, then also tribunal then also proceedings failed to establish his link with his projected father lordship. And lordship regarding voter list, and regarding voter list lordship, what Aziz Mia's case said lordship in WBC 2370 2023, 2370 2023, para 14 lordship I am reading, yes, 2023 Aziz Mia AZIZ MIYA alias MD AZIZ MIA decided on 9/6/2023, 9th of June 2023. Para 14, I am reading. We are constrained to observe that a mere claim by a suspected person by referring to a voter's list claiming a person therein to be his father is not a conclusive proof, and that by doing so, the person has discharged the burden that he is not a foreigner. This is because there is also a further requirement to prove that the person who is reflected in the voter list relied upon is actually the father of the person who makes the claim. The claim will have to be substantiated with further materials acceptable in law. Okay. So, Lordship, in this case, Lordship, on there is no such materials, Lordship, by which proceeding can establish that he is the son of Karim Boksha Sheikh, Lordship, whose name reflected in the voter list of 1966, Lordship. And regarding continuous stay, Lordship, section 682, Lordship, I am referring, Lordship, of the Citizenship Act. Because there is a gap of 15 years since 1970 to 1985. And since 1985, Lordship, discrepancies arises in each and every document, Lordship. অকল ভোটাৰ লিষ্টখন প্লেচ কৰিলে নহ'ব। আদাৰ মেটেৰিয়েলছ লাগিব, ভোটাৰ লিষ্ট থকা মানুহজন তেওঁৰ পেৰা 14। আজিজ মিয়া, আজিজ মিয়া। Vegetarian hotel. Oh.
Please, may I repeat this? Wait.
Yes. For our knowledge, please get us the relevant paragraphs from either the election manual. Latest election manual is 2023. So if it has been updated, I'm not aware. Regarding the preparation of electoral roll. Now, I'll just give you a background. Number one, under Representation of People's Act 1950, the electoral rolls are prepared. 13D is about the parliamentary constituency, and section 15 is regarding the election of the legislative assemblies. As per the manual, I think in the country there are 16 languages used, but I am a bit outdated. There will be languages, the electoral roll shall be prepared in a language which is approved by the Election Commission of India. So in respect of the state of Assam, we need a specific instructions only with regard to the state of Assam as to the language in which voters list or electoral rolls are prepared in the state of Assam. Only that much information. It is for our consumption. We want to understand this issue.
So, my lord, I will take instruction.
Yes, you take your time, 1 or 2 days, and get it by them. Okay. That's all.
Yes, Lordship, only one submission, Lordship, regarding written statement, and written statement is totally vague, Lordship. Why I am saying, Lordship, their date of birth was not mentioned, although place of birth was mentioned, Lordship. When his fathers died, Lordship, that was not mentioned, Lordship, which is very important to establish his citizenship in this case, Lordship. And Lordship, after initiation of proceedings, Lordship, he get the death certificate as well as next to kin certificate, Lordship, from the concerned authority, Lordship. After 23 years of the demise of his father's, Lordship, where Lordship father died in the year of 1993. And death certificate was collected in the year of 2017. And Lordship, similarly, Lordship, next to kin certificate also, Lordship, it was collected in the year of 2017. That's all, Lordship.
So Lordship, may I reply now or Lordship after the information received from the
No, no, that is for our own
Lordship,
understanding of the law.
Lordship. As my learned friend pointed
Here,
out that
here that issue will not come because of the fact that in your voters list, the only 2 copies say that they are certified copies, and others say that they are translated copies. So those are not certified copies. So that
Okay.
issue in your case will not arise.
translated copy of electoral rolls are also certified copies, Lordship, as because the above portion, it says date of application of the copy, though no date was mentioned.
No, but we
by
don't
all.
know. Once it is a certified copy, then it has to be within the ambit of section 76 of the Evidence Act. It must say that it's a certified copy.
Lordship, it is reflect page 24, that is 2010 voter list, Lordship. Though it is written as translated copy of electoral rolls, but Lordship, above that, your Lordship will find date of application of the copy, date fixed for notifying the
No,
requisite.
we understand that, but you see, that's why after one incident which happened, in fact, very few in very few cases, I asked my court master to give a what do you call a copy from originating from the court master. we normally say that use a downloaded, in my orders, I always make a comment that it should be a downloaded copy of the order. Because that then, whatever takes place is there. But if I ask my court master to give it and he gives a true copy, then the question will become that he is not a person authorized under section 76 or 78 of the Evidence Act to give a certified copy. Therefore, a true copy is as good as uh, what you call unendorsed copy of an order, because he's not authorized to give. So that is why normally in my order I make it very specific that it should be a downloaded copy, and the court, either the court master will provide or something, and they will act upon it.
Lordship.
But
Then
actually,
we
the
get
orders of the court will have to be implemented by way of a certified copy. So what we do is just to facilitate certain procedures, but it may not be a legal way to do it. But at times we bend what you call our approach because of the fact that if I want some directions to be done in 1 or 2 days, possibility, if I ask Mr. Sharma to do it, he will not be able to get a certified copy in 2 days and get it. So that's why this system we have developed to give a downloaded copy and all. So that is for our practical purposes. So whether it is a certified copy or not, that will depend on how we interpret it. We take
Okay.
your statement for it, but
Lordship, it is already, there are signatures below the copies also, senior assistant.
no,
Lordship.
that's why I gave you an example. My court master gives you a true copy, contains his endorsement. What is it worth?
For that, Lordship, maybe election commission is
No,
the
so
competent
that is
person
different
on the-
purpose. But when I ask you a question, downloaded copy or what you call a printout of the copy given by the court master to you, bearing his signature, what is the worth of it?
Lordship, as that is not a certified copy, but if.
So
if so,
it's just a convenience that we are creating for certain purposes, but that is not the correct way of doing it. So even if my court master gives you a copy, what if you ask a question, what would be its sanction in law? Then I have to say in the negative.
But Lordship, these are provided to the petitioners
No, we
only upon
understand that.
application being made by the petitioner.
We understand that.
So their
Still-
signatures are also there, Lordship, that signature Shimanta Kumar Das, ACS Electoral Registering Officer, Lordship, Registration Officer. So he put his signature while providing the certified copies, Lordship. Only the procedure may not be correct. They have translated it and then provided to us. They ought to have provided the original copy, Lordship. Normally it is written in Assamese, Lordship. So they are ought to have required to furnish the copy to the proceeding in Assamese, but instead of that, they translate it, Lordship. That is not the fault of the petitioner, Lordship. And in my learned friend's submission, that is WPC 2460, he एक मिनट this position.
Yes, you open.
Right now, we are not going into that aspect. It is for you to convince us to show us the law. You see, the reason is you have seen it when we prepare the High Court Registry prepares a paper book in a criminal case. There are certain documents which are in vernacular. Maybe from here it is in Assamese, from Barak Valley it will be in Bengali. But when a translation is made, the translator of the court puts his or her signature to authenticate the translation. Now, let us say, for example, in this, in one of the voter lists at random, page 21 is one.
There is no such signature, Lordship.
There's nobody who says that this way authenticated.
Lordship. But Lordship, kindly compare page 18 and 21. Kindly compare that 1966 voter list certified copy of electoral roll. That page also, Lordship, there is no date mentioned for date of application for the copy, date fixed for notifying the requisite number of stamps and folios, and date of delivery of the order, date on which the copy was ready. There is nothing mentioned on that page also, Lordship.
Yes.
But last part, Lordship, compared by signature of senior assistant officer, then signature S. Hussain electoral registration officer,
Correct.
and last part election officer. The same signatures are available in the translated copies also, Lordship.
Correct.
The same manner, Lordship. So it is they are the public officers, Lordship, they are giving, and even Lordship in Kirtan Sahu, it says public documents need not to be proved, Lordship.
Okay.
Kirtan Sahu, Lordship, that is High Court of Odisha. This is a 3-judge bench decision, Lordship.
What is the citation?
Lordship, I have provided 2 copies, Lordship. Para 7, Lordship. Last page 4. The electoral roll being a public document is admissible in evidence, and it is not necessary to prove the source of information on the basis whereof the facts stated in the roll were recorded, nor it is necessary that the person who prepared the electoral roll has to be examined in court to prove the roll as a public document. It is admissible under the provisions of the Evidence Act, as was indicated by the Judicial Committee in 1879-7. IND APP 63, PC Rani Lekhraj Kaur Babu Mahpal Singh. The entry having stated that relevant fact, the entry itself becomes by force of the section a relevant fact. That is to say, it may be given in evidence as a relevant fact, because being made by a public officer, it contains an entry of a fact which is relevant. We would accordingly answer the question referred to us. Thus, the electoral roll prepared under the Representation of the People's Act is admissible in evidence without the author thereof and the person supplying the information being examined in the case. It would therefore follow that the view expressed by the division bench in so and the 3 other cases already referred to by a single judge in this court.
There's a difficulty to accept it. I'll tell you why. We were trying to read this. We took a lot of time to read this few documents which were there before us. We had taken some time to study the internet, and we failed to find anything anywhere by virtue of which, under the Representation of the People's Act, electoral registration officer is authorized to make translation and give it. We have failed to find. I don't say my finding, my research was very perfect, but though imperfect, we have not found anything or no material on record which permits electoral registration officer to make translation and give copies.
Lordship. In fact, Lordship, then my submission would be, Lordship, there was no objection raised by the respondents at the time of
We are not taking any adverse. We're just trying to understand the law for which.
Objection raised at the time of admission of the document, Lordship. The petitioner would have taken a different course, Lordship. But they never.
Fortunately, there are many judgments which say that inadmissible document, even if no objection is they
Yes,
cannot
yes,
make it
Lordship.
Lordship.
admissible. We'll take a short break and come back.
We cannot say that these are inadmissible, Lordship.
It's okay. We're not taking a view. We're just
Lordship.
discussing.
Lordship.
We're not taking a view. Not, you're not hearing with a closed mind.
Lordship will continue in
Just take a
second.
break and come. Anything more? Okay. Yes.
Rule 33 of
Conduct of election rules. Which page of this book? Hmm. We've seen that. Thirteen. Which one? Farhad Ali, yes. That is, it's okay, we have it. Farhad Ali. That is, what is the citation? 2024. 1 GLT.
Materials on record and without arriving at any decision have been noticed. We also wanted to know as to what procedures have been followed by the tribunals in declaring the proceedings to be citizens. We are particularly interested in view of a submission made by the Learned Council for the state of Assam in the Home Department that statistically speaking, in about 85% of the referred cases, the proceedings have been declared to be citizens. We are concerned that if the proceedings have been declared to be foreigners without stating any reason and without analyzing the implication of the materials being produced, and if the same procedure is adopted to declare a proceedee to be a citizen, there is a good possibility that many number of proceedees who may be foreigners or illegal migrants have been wrongly declared to be citizens by the tribunals. To examine the aforesaid aspect, we required the Learned Council for the state of Assam in the Home Department to make available a good number of judgments on a random sample basis from the tribunals all over the state, wherein the proceedings have been declared to be citizens. We have perused all such judgments, and it is noticed that in some of the decisions by the tribunals, a good reason order had been passed based on analyzing the materials on record and arriving at a decision. But we are afraid to observe that in much many more other orders, the same procedure of describing the materials produced is adopted, but without analyzing the implication of the materials or without stating any reason, and without arriving at any decision, a conclusion is arrived that in the view of the tribunal, the proceedee concerned is a citizen. In some of the matters, it is noticed that even there is no proper recording as to what material has been relied upon, which would be a basis for the conclusion arrived. Such procedure adopted would have a far more serious consequence. In view of the above, almost 85% of the references have resulted in the proceedee being declared to be a citizen, where it is noticed that in many such cases, neither any decision nor any proper adjudication had been made, a conclusion had been arrived, without stating any reason or without even analyzing the implication of the materials produced. We require the Secretary to the Government of Assam in the Home Department to conduct a departmental review of all such references. So it was, Lordship, in that aspect also, this court gone into that, like, Lordship.
There are few students of law behind. Can you come forward? Yes. Have you been able to follow what was being what is being transpired in court? What issue of law is being raised? Could you follow? No. You see, in this case, there's a certified copy of there's a voters list which was proved. Two of the voters list say that there is a certified copy of the electoral rolls. Other two or three, they are translated copy of the electoral roll. Now the issue is whether the objection which is raised by the learned counsel for the petitioner is that had an objection been raised at the opportune moment, then the petitioner herein could have brought an appropriate copy and prove it. Now, I don't know whether tomorrow you will be here or not, but if you are here tomorrow, then before 10:30, before we sit, you tell the court master we'll come a bit 2 minutes early, and then you can address us on the issue of manner and mode of proving a documentary exhibit. Correct? You may not know the procedural law, so therefore you can just note it down. It will be Order 13, Rule 3, then of the CPC. One of you can write down and share it with the others. You're from which college? Nerim, okay. And Royal Global. Order 13 Rule 3 of the CPC, Order 18 Rule 4 proviso to the CPC, Section 76 of the Evidence Act. And then conduct of election rules. There you will get in the conduct of election rules, you will find 2 or 3 provisions. Those may not be relevant for the purpose of our determination, but this CPC is spend some time fruitfully in making research and then tell us before 10:30 to the court master, tell us, we'll come a bit early. The court time we will not spend in interacting with you, correct? Prior to 10:30, please come over. Okay.
Regarding rebuttal lordship, I want to rely on one of these code lordship, 2018 4 GLT 360. 2018 4 GLT 360. 4 GLT 360. WPC 2641 of 2017. State of Assam and Andhra versus Wahabali. OHABALI. Para 16 lordship. Lordship para 26 of the Parvananda Sonwal's case, Lordship 1 2005 5 SCC 665. Okay. Not necessary to read Lordship at this moment. And Lordship regarding certiorari jurisdiction, Lordship, I want to rely regarding certiorari. Lordship May 2023 SCC online. Yes, Lordship. SC 996, para 50, 51, 52. As well as Muslim Mandal also says Lordship, para 112 of Muslim Mandal. Lordship, regarding certiorari, it says 112 and 113. May I read, Lordship? Yes. 112 and 113. One three Sanlal Gupta's case was disgusting. There are 113.
For the petitioner, also heard all the respondents are there. Mr. Islam on behalf of Mr. A.I. Ali. The arguments are concluded, judgment is out.
That lordship, that Wahab Ali was cited in another writ petition lordship, that is Moniruddin Ahmed. In that case, lordship, he was declared Indian by this court, lordship. That case also I argued.
Give
lordship.
the
Lordship, I have-
citation to
Yes,
the court master.
lordship. That is, I'll see whether it is reported or not, but I have the number WPC 2131 2018.
Just let it,
Lordship.
give it to the court master.
GLT Sabasana, GLT হয়েছে। In that case also, they have cited Wahab Ali Lordship, that in spite of that Lordship, the writ petitioner was declared Indian by this court.
Give the number.
Lordship.
Not remember. Obliged, Lordship.
Item 3.
Yes, Mr. Ali.
My lord, in this case, as many as 4 witnesses were examined. The petitioner was examined as DW1 and his brother, her brother, was examined as DW2. And her brother was declared as an Indian citizen. Proceeding was initiated and thereafter examined and found to be an Indian citizen. And DW3 is a Gaubura, my lord, who issued the certificate, examining the link with her father. And DW4 is the Panchayat secretary who was examined as DW4. He issued the certificate by certifying the link with her father. So far, the parents of the petitioner, those names were appeared in the voter list of 1966. Lordship may kindly see page number 10. The names of father and mother.
Is the record? I mean, record. Watch it.
Page number
Okay, I missed it.
Exhibit A, my lord.
Huh? I vaguely remember that this, where is the earlier opinion? Which page?
My lord.
Of your brother?
My lord, my lord.
Which page?
Page number, exhibit F, page number 20, my lord.
Page number 20.
220.
Now this, I vaguely remember that all orders passed by this member were asked to be reviewed. What had happened?
I have to take instruction. Lordship.
Because he has not made any discussion, no appreciation of the documents.
Yes. Yes.
Against, against this presiding officer, I think his service were terminated and then all his orders were asked to be reviewed. That is what I vaguely remember, but I may not be correct. Find it out.
Make an observation regarding this lordship.
No, we are not making any observation. You find out, you have the name now.
Yes.
You just find out from the authorities. Where is the land documents of yours?
My lord. Impugn order.
No, land document.
Land documents, my lord. Land documents, page number 22, my lord. Revenue paying, received, my lord. Revenue was paid by the parents, my lord.
Page number 22.
22. This was exhibited as exhibit Z, my lord.
But where is the land document?
My lord, other land documents were not exhibited, my lord. The documents regarding her parents, my lord, and brother, who was declared Indian, at the voter
Is
list.
this, you have the original of this document?
My lord, the original right now I am not having. But I think the LCR has come, my lord.
But this can't be a correct document. You see this? This is a revenue receipt.
Only revenue receipt. So far,
Is revenue collected by circle officer? Or subdivisional officer? Who is the authority in Assam to collect land revenue? So far as we understand is the Mozadar.
most of them.
Does Mozadar use the seal and seal of the SDO? No,
No.
we'll have to send it for forensic inquiry. Mr. Sharma, you have a serious issue here. Look at this exhibited document. You see, this is a land revenue receipt. It's a photocopy, but still it's a land revenue receipt. Contains the seal of the SDO. But the question of the court is who issues land revenue receipt? It will be the Mozadar. Does the SDO have power to receive land revenue? Make an inquiry. Make an inquiry and tell us. Maybe your that previous opinion of the can be suo motu opened. It's a Miadipata land. No, the type copy is at page 22 of the writ petition.
23, the body copy, 23.
You go to that website, find out of this land. Mr. Sharma, you go to the website, have it downloaded and then see, examine whose land this is. We'll give you time. We'll take it up after a week. Okay. Give an extra copy of the writ petition to Mr. Sharma. Let them make an inquiry. This can't be permitted. All sides are duly represented. On a perusal of the records of the tribunal, it is noticed that a document which is a land revenue paid receipt, the same was marked as exhibit G, correct? Mr.
My lord,
Ali, it is G,
Z, my lord.
exhibit G. Full stop. They said land revenue receipt contains the round seal of the sub-divisional officer Borpeta. So according to the court queries, who is the competent authority in connection with the said document, available at annexure G to the writ petition, as to who is the competent authority to collect land revenue, specifically whether it is the Mozadar or it is the subdivisional officer, Barbeta. Full stop. On the query of the court, the Mr. P. Sharma, an additional senior government advocate, as well as Mr. G. Sharma, an attorney counsel of the active matters, pray for some time to obtain instructions and to address the court. Full stop. Accordingly, matter stands adjourned today. List on how much time? Okay. List the week commencing 18/8/2025. And the other query also, you please keep in mind. Yes, about this.
Item 5.
Till then, the earlier interim order may continue.
Hmm?
Till then, the earlier interim order may continue.
Earlier interim order, did we give a short interim order?
It was a bail order, man.
Okay, interim order past arrest and is extended till the next date of listing. The original order did not have a time limit, but on the last occasion, I think you made a prayer before the court give it till the next date of listing. Again, we are making it next date of listing. So that was not the original order. Original order was you're granted complete bail.
My bad. How will I lose?
Yes.
Yes, 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 yes.
Item 5 for hearing.
Please, your lordship.
Yes,
Can this matter kindly be taken some other day, lordship?
some other day.
Yes, your lordship.
Okay, on the prayer made by and counsel for the petitioner, the matter stands. You say first, both sides are represented. John today. List on 25/7/2025. Published.
Item 6.
My lordship, impugn order at page 25. Ex parte order, my lordship.
That's it.
Relevant portion appears from page 26, paragraph 4.
Notice was up to you.
My lordship, there are a lot of discussions. Kindly see, my lordship, the page, the or lower court record page 35, I think. It is written in blue page.
35.
35. It is small paper is there.
Yes.
Jonani, it is written. Here it is there. They have shown that right hand thumb of the Abdul Shubbur,
Yes.
but he can sign, my lordship. In Wakalatnama and all these documents he have signed. And another important thing is that respondent number 9 and 10 given a statement, my lordship, but their signature is not there. However, I have checked, maybe I am wrong. Their signature is not there.
Of
Respondent number 9 and 10 of my petition.
oh, that's okay. We don't take cognizance of that. The reason is that the police people are trained not to take signature. Therefore, that is a hazard which.
But as per however I've got information, my lordship, they have not given such statement, my lordship.
No, that's different. But you you entered appearance. You entered appearance in the matter.
Well, last part, I have not got any notice. As per the record, I think 31/2018, they have said that they have given, served notice to my wife, my lordship. Because I do have all the documents, my lordship, from 66 onwards. And certified copy also I have bring. Most important thing is they have given the thumb impression, but Abdul Shukur can sign, my lordship. In Wakalatnama also all the documents.
I should think of the family.
page I think in the tribunal. Chance may be given, I would be appeared for the tribunal. Later on, I have appeared, my lordship. Not during that time, I have not got any notice. Otherwise, I could have given.
Page 21, para 3 of the interim. In lordship, 35 was opening in the year 2018, something across people petition.
Notice has been duly served.
But there are certain, their inquiry is questionable, my lordship. What inquiry they have done, that is questionable. They've given that thumb impression of my report. The foundation on which I was, when my citizenship is doubted. And also respondent 910, we have, as I have asked to my senior, they have already, the notice has been served to respondent 9 and 10 also. And how far we know that they have not given such statement before. Later on, we have given our petition, my lordship, and regarding the delay, but it was rejected, my lordship. We have all the documents from 66. So mistake happens from the both sides.
You appeared before the tribunal.
Yes.
Okay. I have already submitted from 66. The original copy is with me, my lordship.
No, but once it is duly served, then we are not likely to interfere. This
But
opinion was passed on 19/3/2018 after giving you several opportunities of filing a written statement.
it was not served. My means on time, several occasion on third, I've got, I think, as per their order, 30.
We appeared before the tribunal Based on not
31
serving in office. notice
31,
authorized at this-
31, 2018. It is said that it is served to my wife as per how far I've seen the record on it. Yes, my lordship. And then second point is that, my lordship, there are certain discrepancies there, my lordship. Okay, I will
No.
appear before the tribunal, my lordship.
No, appear before the tribunal doesn't, that opportunity you will not get. Once the service is there and you appeared before the tribunal, you sought for an adjournment. After that, you did not file your written statement and then the ex parte order came. It's a willful neglect. For that, we cannot interfere with the impugn opinion. The impugn opinion is in 2018. You have filed this writ petition in 2020.
In certified copy was obtained in the year of 2018. lordship.
Certificate copy obtained in 2018.
But it is also true that, my lordship, that whatever the inquiry was done by the police, and there is also some, on what ground they have doubted my citizenship. These are also, my lordship, has to be taken into account, my lordship.
We will not interfere. You did not contest when the opportunity was given to you. You could have
Maybe-
taken that defense. Nobody has stopped you.
Well, may I miss whether my signature was there, that on that day I received that 31, 2018.
Your signature.
No, my wife's signature, means petitioner's wife's signature.
Oh, you could have checked the records. How could you start an argument without looking at the records?
Records I've seen, maybe I missed, my lordship.
You have definitely missed it. You must have some, you see,
No, I asked,
I'm not giving a sermon. I'm not making any statement to hurt you. But the question is that when you have an LCR, you must know how to read it. Reading of LCR hardly takes a minute's time.
yes, my lordship,
So that's something you should learn.
yes.
And at times we say we both are proud that we have some experience in looking at the LCR. People have a wrong notion that to become a good lawyer, you have to be a high court lawyer. No,
Dada,
you must have some trial court experience. What you saw was a summons given by the police for an inquiry. That is of 2015. This is to 29/27/1/2018.
Wife was signature. It was about, it was 21.
You did not get it.
Yes, my lord, 21/1/18.
21 was 27.
21 it is written.
27/1/18.
27/1/18.
After appearance, lordship.
After that, you appeared. You took a lot of adjournments. Look at the order sheet. You took not one, several adjournments. After that, you cannot come and say that, well, I had no notice. Otherwise, you would be a busybody going to court, looking at records and finding your name, you appear just like that. I would never visit a court to look at the record and find out my name and then I will start appearing in the matters. I would not do so. How in this petition you are connecting yourself to your projected parents?
My lordship, kindly come to voter list, my lordship. Starting from page 16, 1997 voter list. Page 15 is the typed copy. Then page 13. His father died in the year 1973, my lordship.
Yes.
Father died in the year 1973. His name first time appeared in his father name appeared in 19 voter list 1966, my lordship. I have the type copy, which is at page 9 and 10, my lordship. Then voter list of page 11. Here the age is little bit wrong. It should be 38 years, but it is written 34 years. Then from 1993 onwards, his name appeared, my lordship. Some Abdul Subbur, some Abdul Subbur, name variation is there and age variation is there, but his name appeared regularly with same village, 90 Jamuna Mukh. Everything is same. Mother's name also appeared, my lordship. Then voter ID card is also there at page. Their name is little bit wrongly written, my lordship.
Is there any document other than the voters just to show the name of your parents?
My lordship, that Kubul Nama is there, my lordship. That marriage annexure 5, page 17. And readable portion is page 18. Annexure 5. It is written Abdul Shubir Pita Mito Shafiqul Rahman.
You have the original one with you?
Original right now. I have the original voter list copies, my lord.
No. Nama you are trying to show us.
Okay, my lord. Just 2 minutes.
It's, and and along with this, respond if for the purpose of a male, a Kabinnama would be a good document for proving the parentage. For female, I can understand, but is a Kabinnama a good document to prove parentage of a male person?
I have to check. My lordship, my lordship right now I don't have my lordship. I have the Xerox copy only, I find it out. But if required, I can bring before this court. If And how far I know that cable number I have not given for proving my age, my lordship, but for
We had asked you about the original of the Kabinnama because please come to page 18,
yes,
page 18 or 13, I don't know.
page
18.
19 and 18.
18 is the document,
Yes,
right?
yes.
Yeah, in the bottom you'll find Dulhar Sohi, that is not there.
Dular, so yes.
Abdul Bakar, I said. Subbu.
Abdul Subbu. Abdul Subbu.
Hmm.
Maybe she gives thumb impression that has not come. I will bring the original.
No, his signature is there in the left side. Where is Dulhar?
Abdul Subbu.
Dulhar Sohi. Mohammed Abul.
Abdul. Abdul.
Abul.
Abdul. Law. It is law, I think.
Petitioner is Abdul. And signature is Abul.
They have written.
Girl signature is not there. Voter list is Abdul Sudur.
Abdul
Subur. And you just now said that he knows how to write.
Yes, my lord. Even Wakalatnama, I have seen every documents. Yes.
No, we understand. We are not for a moment saying that you are incorrect. But if he signs is Abul Subur,
I try to bring the original copy of that.
no, we're not adjourning for that.
Right, so people are all obvious. Regular movie.
So he, like this was not husband register. That's it.
My lordship, this was given before the magistrate, my lordship, one document. Might have post copy given to the post copy. कोई senior को हम तो बेंच पर senior बनना पाओ कुछ कोई सेकंड senior ऐसे तब बेंच पर मुझे अपना ठीक है These were given later on, my lordship. There is also another land document is there, my lordship. But all this given later on, my lordship. What is the connection now? নাই মোৰ এনেকে খুলি খুলি চাই আছে এইবিলাক খুলি খুলি চাই আছে মোক দিয়া নাই তো কি কৰিম কেনেকে পঢ়ি আছে নহয় ভাইকে তো সিগনেচার বসে ওকালত signature তখন তো তার থাম ইমপ্রেশন আছে অল্প signature আছে
Page 18 is the copy of register.
Yes, my lordship.
So since it's a photocopy, we take it that this would be from the original one. It doesn't have the signature of both parties.
My lordship,
One
may I-
is Muhammad Abul Subur.
Abdul Subur.
Then there's a signature of
His
the
wife.
Ukil, Muhammad Sarifuddin Laskar. And then next page, page 19, there's a signature of the young brother Hakir Muhammad Abul Mannan. So it's done in presence of one
Witness.
person, one witness.
My lordship, apart from that, I've also got the transfer certificate, my lordship. It was taken later on. This is the original, I think I have. Headmaster has given from the original.
Where is that document?
Document is not annexed because all these documents were given later during these holidays, my lordship. This is the, I think, original copy of that transfer certificate.
Let us see that. Mr. Sharma, just examine it and send it to us.
This is not an admissible document, lordship.
If the register,
In the year of 6/11/2012, after
Let-
initiation of proceeding, lordship. First of all, lordship, it bears that emblem is not admissible document. And lordship, it was issued on belated stage,
headmaster,
lordship. After
we can take it from registry, Your Honor.
proceeding, after initiation of the proceeding.
We can also take it from register of that school.
Again,
একে বস্তু xerox copy হলো register. Is given comic number.
Abdul Siddiq. Abdul Salam. School plan আপনি কেন দেখুন
If required, I can bring it on record also, my lordship.
No, we take it from you because we don't want to adjourn the matter. No, sorry, we don't find any good cause to upset the opinion. You are An Islam,
No, TK Day, my lordship.
PK,
TK Day.
TK Day.
On behalf of An Islam.
Okay. Heard Mr. TK Day, Learned Counsel, appearing on behalf of Mr. An Islam, Learned Counsel for the petitioner on record. Also heard, all the respondents are there. That's well. By filing this writ petition under Article 226 of the Constitution of India, the petitioner has assailed the ex parte opinion dated 27/3/2018, passed by the page 25, passed by so and so and so and so. They were declaring the petitioner to be a foreigner of post 25/3/1971 stream. Next paragraph. To seal the said ex parte opinion, the learned counsel for the petitioner has submitted that the notice was not properly served on the petitioner in accordance with law. Stop. It is further submitted that the inquiry made by the inquiry officer was perfunctory and not done in accordance with law. So it is further submitted that the inquiry officer had examined two witnesses. But as per the LCR, the signatures of the said two witnesses were not taken. So in the said connection, it is submitted that the petitioner has implemented the said two witnesses as respondent numbers 9 and 10. And despite service of notice, the said respondents have not appeared and denied the allegation. Against them. Next paragraph. The learned counsel for the petitioner has submitted that that his father namely, what is the name of your father?
Shafiqul Rahman.
Where do I find the name? Where do you find that name?
Can you
your
come to
father?
the voter list of 1966, my lordship?
Safiqul Rahman, within bracket, since deceased, had died in the year 19, whose name appears in the voter list of 1966, had died in the year 1993,
73, my lordship, as per my petition, my lordship. Sorry, my lordship.
73.
73, 1973.
Oh,
He-
okay, the
his-
year
his-
1973. Which had two voter lists, 66 and 1970. And died in the year 1973, when the petitioner was about 2 years of age. '73, you have not stated anywhere
Yes, my lordship.
where.
His father died sometime in the year 19, page 4, my writ petition, my lordship.
Yes, we are there.
But mother is still alive and voting.
It is noted the father died when he was 2 years old. It was
No, it is not.
page 4
Page
for 73. Achha, father died sometime in the year 1973 when he was about 2 years of age. And after the death of his father, he's residing with his mother till date. And his name appeared in the voter list of 1993 along with his mother. Musammat Sakina, Sakina, Sakina Bibi. Stop. Accordingly, comma, by referring to the documents annexed to this writ petition, which are the voter list of the year 2005,
starting from 19.
comma, Kabin Nama, so make it Kabin Nama, then it is voter list from 2005. Then voter list of 2010. Probably submitted that the petitioner has sufficient documents to prove that he is a citizen of India. And accordingly, the land counsel for the petitioner prays for an opportunity to the petitioner to contest the proceedings by filing his written statement before the learned tribunal. Full stop. It is further submitted that the petitioner, the petitioner has recently provided to him with a copy of transfer certificate dated 6/11/2012, issued by the headmaster of what is the name of the school? This is again something we can't read.
I can read only LP school, my lordship.
Hmm?
LP school, the stamp has not come correctly.
Okay. Okay, school. However, the name of the school is illegible. Comma stating that
LP school.
Mohammed MD Mohammed Abdus ABDUS Subur SUBUR was a student of the said school in the year 1984. And he had passed out class 4. Next one. The learned standing counsel for the FT matters, I suppose the made this writ petition. Next one. Peruse the materials available on record and also examine the records of the tribunal, which has been called for and received by the registry. Next one. Insofar as the mode and manner of service of summons of the tribunal is concerned, the tribunal oblique summons notice is concerned, the records reveal that the notice of appearance before the learned tribunal after being returned without service on several occasions was ultimately served on Mahmuda 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 Begum, wife of the petitioner, who has received the notice by fixing her thumb RTI, right hand thumb impression on the service report. Full stop. You find that the same name, the same said name of Mahmuda 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 Begum tallies with the name of the wife of the petitioner, as disclosed in the copy of Kabir Nama within bracket Annexure 5 to the writ petition, bracket closed. Full stop. Furthermore, the records reveal that as per order dated 30 January 2018, the process service report was returned back to the tribunal, and the learned tribunal had recorded that the notice was duly served as per section, as per para 3 within bracket 5 bracket close against small bracket small b of the Foreigners Tribunals Order 1964. Full stop. However, the matter was adjourned to 13/2/2018 for written statement and surety, etc. Full stop. However, later on, the notice of the court was brought to the petition number 2834/2018, whereby a prayer was made for appearance, written statement, and production of the surety, etc. Full stop. Matter was adjourned and thereafter taken up on 13/2/2018, on which date, on the prayer for adjournment made by the learned counsel for the petitioner, the matter was adjourned to 27/2/2018. So once again, on the prayer made by the made by the petitioner, the matter was adjourned to 16/3/2018. Thereafter, the matter was again adjourned to 19/3/2018. So as per order dated 19/3/2018, the prayer for adjournment was rejected, and the matter was directed to proceed ex parte against the petitioner. The case was fixed on 27/3/2018 for ex parte opinion. Full stop. Accordingly, on 27/3/2018, the learned tribunal expressed its opinion that the petitioner is declared as a foreigner post 25/3/1971. Next, the reports further reveal that by petition number 3470/2018, the petitioner had filed a review petition the learned tribunal by order dated 24/7/2018, upon perusal of the materials on record, observed that the petition is not supported by any delay continuation petition, as it was filed after a gap of 3 months and 27 days, which is beyond the prescribed period of limitation. And secondly, the petition in the review petition was in the name of Sufia Begum, was found not to be in relation to the petitioner in this case. And therefore the petition was rejected. Lucky Kublo. Sufia Begum. This is- Keep on it. Yeah. Very good. देखो, फिर ना, itu tuh kulit malah, itu kulit malah. Next para. As regards the manner in which the process was served on the petitioner, we find that the notice was duly served on the adult family member of the petitioner, and therefore the learned tribunal had rightly accepted the service of notice in terms of paragraph 3 within bracket 5 within bracket B of the Foreigners Tribunal's Order, 1964, by treating the notice to be duly served. Full stop. The manner of service can otherwise not be challenged by the petitioner in this case, because on the date fixed for appearance, that is on 30 January 2018, the petitioner made appearance before the learned tribunal and prayed for adjournments on the said date, as well as on 4 subsequent dates. And on the 4th occasion, that is on 19/3/2018, the petition was rejected and the case was ordered to proceed ex parte. Full stop. Next. We just give a cap. In the case of so and so, this court has held that. Just say that we will give that judgment. Next one. Insofar as the manner in which review petition was filed, We are, the court is surprised to note the pleadings made in paragraph 9 of the writ petition, wherein it has been specifically stated that having come to know about the ex parte opinion, the petitioner had obtained the certified copy of the order on 23/5/2018 and intended to file a review petition for setting aside the impugned order dated 27/3/2018. And accordingly, he applied for all certified copies of all orders and process service report. Full stop. However, the record reveals that not only a review petition was filed, which is reflected in the order of the tribunal dated 24/7/2018, but the said review petition was rejected purportedly on two grounds. Full stop. Firstly, that it was not supported by delay condonation petition. And secondly, because the affidavit in support of the said petition was sworn by one Sufia Begum, SUFIA, Sufia Begum, wife of late Ishaq, ISHAQUE Ali. Full stop. In this regard, the records reveal that the petition which was taken as a review petition is in fact is under the nomenclature of an application in inverted comma, an application and application under praying for vacating ex parte order dated 27/3/2018, full stop, inverted comma closed. The same was filed by petition number 3470/2018 dated 24/7/2018, which is signed by the petitioner Abdus Subur. And here's the filing signature of two advocates, namely Nozmal, NOZMAL, Nozmal Islam, as well as one Faiz, Faiz, Faizul, UL, Faizul, Faizul Haq, advocate, Hojai, Shankar Dev Nagar, bearing enrollment number 999/13. Full stop. The affidavit in support of the said petition is in the name of Sufia Begum, wife of late Ishaq ISHAQE Ali, aged about 58 years. Full stop. However, the said affidavit bears the signature of Abdus Subur, duly identified by Faizul Haq, Faizul Haq, referred above. Full stop. Therefore, affidavit with an incorrect nomenclature, incorrect description of name, though sworn before the notary public, namely Sujit Ranjan, SUJIT, Sujit Ranjan Acharji, is no affidavit at all. Full stop. We are also surprised with the fact that at page 54, 55, and 56 of the trial court record, the application under section 5 of the Limitation Act is available. Full stop. The said affidavit, the said petition is supported by an affidavit, again by Sufia Begum, wife of late Ishaq Ali. However, the same bears the signature of Abdus Sabur and identified by Faizul Haq, advocate, and sworn before the notary, same notary, namely Sujit Ranjan Acharji. Full stop. Therefore, therefore, an adverse comment is made by the learned tribunal in its order dated 24/7/2018. That the petition is filed in a lackluster way. Next para. Next para. Resultantly, the court finds that although a petition for setting aside of the ex parte opinion was filed, which was rejected, the said order dated 24/7/2018 remains unchallenged and has retained finality. Next paragraph. The learned counsel for the petitioner has produced a copy of transfer certificate. Full stop. The court would otherwise have required the said document to be produced by way of an additional affidavit. Full stop. However, it is noticed that the said transfer certificate bears the state emblem of the Lion Pillar of Asoka, ASOKA, which makes the document inadmissible in evidence. Full stop. If one reads an authority on the point, the decision of the division bench of this court in the case of gap may be referred to. And therefore, therefore no point would be served in having the said document brought on record by way of an affidavit, which is otherwise inadmissible in evidence. Full stop. Next paragraph. Therefore, comma, this is not a case where the tribunal did not give adequate opportunity to the petitioner to file his written statement and contest the proceedings. Full stop. Therefore, the impugned order. Therefore, comma, the petitioner has not been able to make out a case to interfere with the ex parte opinion dated so and so, passed by so and so, and so and so. So according to the prayer made in this petition stands rejected. Full stop. This generally, comma, this petition stands dismissed. Next paragraph. Let the records be sent back to the Dunnet Tribunal with a copy of this order to be made a part of the court. Next paragraph. We take the opportunity of if we feel it necessary for sending an order, sending this order to the Commissioner Secretary to the Government of Assam, comma, Home and Political, Political and Home and Political within bracket DB Department, so as to examine if any advisory is required to be issued to all the foreigners tribunals to mandatorily enter all petitions filed in their tribunal's register, so that mistakes of this nature of omitting to notice a condonation application does not reoccur in future, as the procedural lapse erodes the very credibility of the tribunals. Can we make an observation here in this order that henceforth, if no petitions are accepted by the tribunals, then the Home Department will have a email address where such activities can be reported. You look at this record, you will be surprised. It is at page 54. If this happens with one tribunal, that means they are doing it at their whims and caprice. That can't be permitted. You take back your documents. You put a flag, I think. Last. No, after that, there's another. We put a flag, no. Oh, sorry. I gave you our file. This is the LCR. First, look at the first part, order sheet. In the order sheet, you will find 4 or 5, 6 pages. Then you find that it is rejected. It doesn't have condonation application. No, only 3-4 pages, order sheet. You've seen that? Order? Yes, next page it is rejected because it doesn't have convention application. You've seen that? No, in the first page, there are 2-page order. Review petition is 2-page order. No, they are going down below. It's not there. That much order sheet is not there. See 2 or 3 pages down the, yes, this one. Yes. Correct. Rejected because there is no condemnation application. Now look at the last part of the record. Condemnation application is there. Page 54. Correct. So if this happens in one case, it may happen in another case. So if the tribunals do not record any petition, your home department will have to create some mechanism where complaints can be made. These things must stop. Next para. The we direct the home and although this writ petitions will stand closed, comma, we direct the Commissioner Secretary to the Home and Political within bracket B bracket Coast Department to inform the court as to what remedial steps they would intend to take if any petitions are filed by the proceedings and not entertained by cancelling the court fee stamps. For redressal of grievances of such cities. And whether it is feasible to have a dedicated email through which complaints can be made by the proceedings that the tribunals have not accepted petitions. Next para. We also direct the Home and Political within bracket B department to circulate a copy of this order to all the foreigners tribunals in the state. That's all we have to raise for the single bench.
No date was mentioned, Lord.
No, you see the in the back the affidavit is there.
Yes.
And you had a great lawyer with you. He types out name differently, signature of different person, name by different person. And we feel sorry for you also because you said that you saw the records. If this is how you read the LCR, then you can't do justice. You see the LCR means you see everything. You'll have to cultivate your habit to read the records, at least when you appear before this bench, at least till my sister is here with us, with me in fact. We issued this, let them take a decision. In the meanwhile, this order will be circulated. Everything will fall in place. This is something which can't be tolerated. I was also a lawyer once. If I file a petition before the court and it doesn't accept it, I would be an aggrieved person. Other matters would be adjourned, taken up in due course.